In this fifth episode of a six-part series on corporations, I'm going to discuss the duty of loyalty and also duties owed by directors during corporate takeovers. If you enjoy this episode, don't forget to hit the like, subscribe, and bell buttons. This is Professor Bias. Today we're going to examine the duty of loyalty and the duty that applies when a corporation is being taken over by another business. A director has a duty of loyalty to the corporation. This means that they must be undivided in their loyalty to the corporation by putting the corporation's interest over their own personal interest. Now, there are three ways that the director can breach the duty of loyalty. First, by competing with the corporation. Second, by usurping a corporate opportunity. And third, through self-dealing. So let's look first at competing with the corporation. The law prohibits directors from advancing their personal economic interests by directly competing with the corporation. And part of this, we need to understand that a director generally does not have as their full-time duties being the director on a board of directors. Right? They have many other duties, right? They could be a law school dean. They could be an employee for another corporation. They could have any other sort of activities, but they happen to serve on a board of directors, which is why we have this potential for conflict. Let me give you an example. Tom is a director for XYZ Inc. As a member of the board, he has access to the corporation's customer list. If Tom uses the customer list to solicit sales from these customers for the corporation that Tom owns separately from XYZ, then he has violated his duty of loyalty to XYZ. In corporate America, this scenario is possible given the makeup of corporate boards. For example, as of the date of this video, the CEO of Walt Disney was serving on the Apple Computer Board of Directors. Now, as Apple expands into new markets, there's going to be information that the Disney CEO picks up that he cannot use to compete with Apple, at least in those areas where they might have some competition. Second, we have usurping a corporate opportunity. A director usurps a corporate opportunity when the corporation is financially able to exploit the opportunity. The opportunity is within the corporation's line of business. The corporation has an interest in the opportunity, and by taking the opportunity, the director will be creating a conflict of interest. Here's an example. John is a director for XYZ Inc., and XYZ Inc. leases a factory from Tracy. Well, Tracy one day approaches John, who's on the board, about renewing the lease agreement. John doesn't bother to tell anyone else at XYZ about this lease renewal, and he decides to personally renew the lease so that he can control the lease. In that case, John has breached his duty of loyalty. John should have disclosed his information to XYZ and not taken the opportunity for himself. I mean, in a way, this is duty of loyalty. Issues are dealing with theft, when you're taking something that doesn't belong to you for yourself. Third, we have self-dealing, which occurs when a director votes on a matter in which he has a personal economic interest. Again, let's go back to XYZ and John. XYZ wants to sell some property to ABC, which John secretly owns. Doesn't bother to tell anyone at XYZ that he has an economic interest in ABC. The XYZ board votes to sell the property with 3 members voting to sell, 2 members opposed to selling. If John was in the group that voted to sell the land, he violated his duty of loyalty because he was self-dealing. He had an interest, he was on both sides of that transaction, right? Helping to sell, helping to buy. John should have disclosed his ownership interest and then recused himself from all further discussions on the sale. I had been at board meetings, and that's exactly what goes on when there's a matter that affects you personally. You say, I'm sorry, at this point I need to leave the room. Can somebody please come get me when you're done talking about this? That's the honorable thing to do. Now, one final note on the duty of loyalty. Not all breaches result in directors being held liable. So sometimes I call this sort of a technical breach of the duty of loyalty. But this is when a director breaches the duty of loyalty. The director can then counter, arguing that nonetheless it was a fair transaction. And there's a test called the entire fairness test. Here's how it works. So the entire fairness test looks at two things: fair dealing and fair price. The deal is considered entirely fair when the process that was used was fair and that the price that was received by the corporation was fair. So maybe John was on both sides of the transaction. If he can show that everything still operated fairly, there was an independent appraisal, the corporation got a fair price, yes, there was a breach of the duty of loyalty, but John will not be liable, again, under the entire fairness test. Now let's move on to the duty owed by directors when the corporation is being taken over by another business, because the duty here shifts. When the directors are aware that there is a takeover attempt, the first step is to determine whether the asking price is fair to the shareholders. If the board determines that the asking price is too low, then the directors may take steps to protect the corporation from a takeover. These steps are called poison pills, which we will review in another module. But once a board determines that an offer is in the best interest of the shareholders, the only duty for the board is to secure the best price possible at the sale. So for example, suppose that XYZ gets an offer from ABC to purchase the company at $60 per share. DEF, another corporation, learns about the offer and they offer to buy XYZ for $61 per share. So you see now we are in a bidding war. Two separate corporations looking to buy ABC, and ABC now knows they're going to be sold. Now, the board at ABC, let's say they believe that the XYZ offer is better because they treat their employees better than the other corporation. The board cannot consider those sorts of things. The only duty at the time of sale is to maximize the value for the shareholders. So even though you have two corporations that are in a bidding war, one company has a lower bid, the other one has a higher bid, you have to go with the highest bid. That is the only duty at the time that the corporation is up for sale. If you enjoyed this material, hit the like button. Also, to avoid missing any future episodes, hit the subscribe and bell buttons. For more resources to help you get ahead, including my blog and newsletter, check out learnlawbetter.com. Thanks for watching.